Hello to everyone who has arrived. I want to thank you for joining us. We will be starting the webinar in just another minute or so. My name is Dan Plaskett, and I am the founder and president of Interactive Estate Document Systems, and I will be your presenter today. Just to give you a little background, I am a CPA and an estate planning attorney licensed in the state of Missouri. I've been doing estate planning since about 1980. So if you're doing the math, that's about 40 years. I do still service a few legal clients in the state of Missouri, but now my primary focus is empowering and equipping people like you to design and create your personalized estate plans and utilize today's technology to handle the legalese and the state law requirements. Okay, I'm going to start our presentation now and share my screen with you. All right, I'm going to move this down so it's a little bit out of the way. Okay. Now on this slide, you may have noticed that the tagline just below our company name, Interactive Estate Document Systems, says will and trust drafting systems used by lawyers now available to you. You notice that it says used by lawyers and not drafted by lawyers. Well, I'm going to talk a little bit more about this later, but I did want you to know at the outset of the presentation that the documents that are created by our clients are fundamentally different than those produced by LegalZoom, Rocket Lawyer, Trust and Wills, and other companies that provide do-it-yourself services. The technology that we offer our clients is the same that I use in my own law practice and the same that's used by over 1,000 estate planning attorneys across the country when producing documents for their clients. So please keep that in mind when we discuss your options for getting your estate planning documents drafted. Now, I'd like to thank you all for coming today and also to offer my congratulations. Now, you may be wondering why I'm thanking and congratulating you. Well, I'm thanking you for sharing some of your very precious time with us today. And I'm congratulating you because we know that statistically, about 70% of the people in Hawaii do not have any estate planning done. So we hope by being here today, you will gain enough information to begin to take action and get your estate planning in order. Now, we know that a crisis can hit very unexpectedly. The events of the past several months have made that abundantly clear. None of us a year ago would have believed that we could be caught in the grips of a global pandemic that has affected almost all areas of our daily life. For many of us, it would have been much better, and for our family members, had we planned ahead. Those family members that have been touched by illness during this time have been especially challenged by not having estate planning documents in place. As we know, this has been very hard on our kapuna as COVID has had really a devastating effect on the elderly. In many cases, it's been impossible to get to the hospital to get important documents signed. So again, it's good that you're here to get ahead of the curve of any future crisis situation in your own life. You know, we know that there are a few reasons why people do not get around to setting up their own estate plans. And the number one reason is procrastination. We all understand and we agree. We know that, we plan to get to things. We've got our own list of things we'd like to get accomplished, whether the list is written down or just stuck somewhere in the back of our head. And down deep, we all believe that we've got a little bit more time. Well, you've overcome that initial hurdle to be here today. You're getting information about estate planning now rather than putting it off another day, and that's a great first step. Another obstacle is the lack of knowledge. None of us want to make a mistake. Many of our clients actually know quite a bit about estate planning. They may have dealt with their parents' estate planning or their estate settlement. They've talked to friends or neighbors about their experiences. They may have read articles on estate planning on the internet or watched YouTube videos on various estate planning topics. However, they also realize that there's a lot of conflicting information out there, so they end up feeling that they really don't know anything, and they realize that they don't know what they don't know. Now, we understand that. And this is particularly true when considering doing your own estate planning documents. Attorneys routinely say things like doing your own estate planning is like doing brain surgery on yourself or similar comments. And if you're considering doing your own estate planning documents using Quicken Willmaker and Trust or the other previously mentioned services referred to, I would add my words of caution for your consideration. But as you will see later, we've eliminated these concerns by creating a step-by-step connect the dots system so that you can be assured that your plan is both right and right for you. Now, there are 6 major concerns when people contact us about their estate planning. Most often, they want to pass on their hard-earned wealth with no court involvement. They would like to avoid unnecessary taxes. They want to avoid going broke from long-term care expenses. They want to protect their family and their wealth from predators and creditors. They'd like to pass on wisdom and values and life lessons to the generations that follow. And finally, they'd like to avoid spending thousands of dollars implementing their planning. So this is our agenda for today. I'm going to talk about wills and trust. I'm also going to talk about how to choose a document preparer. The cost typically charged by local attorneys to prepare estate planning documents in typical cases. And then at the end, I'm going to take some time to field some questions. Okay, let's get into it. So we're talking about estate planning. First question is, so what's an estate? Well, an estate is really everything that you own. It's your house, your cars, your bank accounts, and all of those family heirlooms that you own. It's your IRAs, your 401ks, your pensions. It's your annuities, stocks, bonds, and mutual funds. And additionally, if you have life insurance policies, those are also part of your estate, whether they are policies that you've purchased or policies that have been purchased for you. And you've probably got a lot of those other little things around the house: knickknacks, electronics, jewelry, family heirlooms. Whether or not they have any monetary value, they may have a lot of sentimental value, so they're also part of your estate. And we know that there are a couple of characters always waiting out there in the wings to get their hands on your estate. So first is the IRS, also known as Uncle Sam. And the second is the probate attorney. I'll talk today about how to minimize your interactions with these 2 characters. Now, when we set up an estate plan, we want to understand what's the purpose? Why would we do it? And the one big reason why you need an estate plan is so that you can control whom you want to receive your assets at the time of your death. Now, you probably have friends or family members in mind, and if you know something if you know that something happened to those people, you would want to provide for them. But if you don't write that information down in a formal plan, nobody's going to know that, and your estate may potentially have to go through the probate court, which means that a judge is going to decide. Now, if that happens, the judge is just going to apply the law, which means that your assets may end up with that brother whose wife you don't really care for, or maybe that sister that you haven't spoken to in years. If you want to avoid a situation like that, Having a written plan is going to go a long way to avoiding any trouble. Now, you also need an estate plan to control when you want your beneficiaries to inherit. Most people say, well, when I die, that's when they'll inherit. But there's much more to it because you could have young children or grandchildren and you want to provide for them, but you can't give a 5-year-old a large sum of money and just say, go at it, right? So we need to put some guidelines in place. We need someone to manage the funds for them. And we also know that about 10% of families have special needs or disabled family members. We don't want to just give them a chunk of money because if they're on government benefits, for example, Medicaid or SSI or some other benefit, it could really complicate matters for them to directly inherit money. They'll have to spend down the money, become disqualified from those benefits, and reapply. So we want to do special planning for those families. And actually, many families have at least one family member who we love and care about as much as everybody else, but they just don't make the best decisions. So we want to do some special planning to control the decision-making process there and sort of handle everything so that the money is not blown on things that maybe we wouldn't agree with. Now, you also need an estate plan to be handled by the person of your choosing. For many people, that's obvious. But again, if you don't write it down, no one will know who you want to be your fiduciary or your representative. Now, this may be an executor, a personal representative, or a successor trustee, and we'll discuss those terms shortly. We really want to have all that written down so that there's a plan to follow, because if not, you're going to go through probate, and the court is going to appoint someone. That person may do the opposite, the exact opposite of what you wanted done with your estate. Now, we also want to avoid cost. None of us want to pay anything more than we must for anything that we purchase. So if you set up a proper estate plan, what you're going to see is that your pie is going to be mostly green. The goal should be to give everything to your family members, your friends, and this red portion, the court fees and taxes, the attorney's fees, should be minimal or even completely avoided. Again, this just takes proper planning. Now, when we talk about costs, there are different types of costs and fees involved. So what I'm primarily referring to today are the costs associated with what we call conservatorship, probate, and death taxes. So for those of you that are concerned about the issue of death taxes, I'll be talking about that. And it may not be as bad as you think because it's really, the laws have changed drastically over the years. Now, what we'd like to do here is, rather than talk about the technical aspects of setting up an estate plan or a trust or a will, we like to illustrate everything by telling you a little story. So I'd like you to meet John Q. and Mary Doe. Now, they're a married couple of over 40 years. They both recently retired, and they're trying to get their affairs in order. So as a first step, the first step that they took was to see a financial advisor who helped them figure out where they stood financially. So after this review, they determined that they have about $900,000 in assets. Now, you may be thinking, well, I'm not John Q. or Mary because I'm single or divorced or widowed, or I have much more than 900,000, or I've got much less than 900,000. Well, I want to assure you that regardless of your marital status or the size of your estate, everything that I'm talking about today is applicable to each of you. In addition to John Q. and Mary, I would like to for you to meet their other family members, because you're going to be hearing about them as well. So here's their son, Jack. Now, Jack is the oldest child. He's what we would consider the black sheep of the family. He never really cared much for school, dropped out a long time ago, and pretty much just hangs out at the beach with his friends, talking story, drinking, and partying. He's happy with his lifestyle. And of course, John Q and Mary are not very happy with his life choices. They would really like him to go back to school or get a job or just do something productive. Now meet their daughter, Susan. Now, Susan is their youngest child, and she is her brother's complete opposite. She studied very hard in school, became a CPA, and now operates her own firm. So that's our family dynamic, and that's the Doe family. Now, I also want you to watch out for this guy. We're going to call him Oscar the Opportunist. Just remember his face. You'll be seeing him a little bit later. Now, John Q and Mary have a lot of options, just like we all have a lot of options when it comes to setting up our estate plans. Now, they can spend it all, which sounds like a good option, but the problem with spending it all is that you might spend it all too quickly and you're still here. So that's not the best way to plan. They may die intestate, which literally means you die without a will. They could own assets in joint tenancy, which means that if one spouse dies, the other spouse owns the asset and it avoids probate. Sounds like a pretty good deal. But joint tenancy is typically just a Band-Aid, and it's not going to be a final solution, because once all of the joint owners are deceased, that jointly held asset must still go through the probate process. So it's better to get it taken care of ahead of time. Now, sometimes people just consider transferring assets to their children where they're alive, while they are alive. There are some pros to that, but there can be some cons as well. And we're gonna look at that. So that's probably something you would want to consider carefully and explore the pitfalls to see if it makes sense in your situation. They'll choose a will or a bare bones trust, or maybe even a more comprehensive revocable living trust. Those are all options for them and for you. So John Q and Mary put together a list of the things that they'd like to do. They want to exercise more. They want to plan a vacation. They'd like to plan their retirement, create some wills, and plan their funerals. Well, many of these things are not all that exciting. So as you might imagine, they're going to decide to plan their vacation first. And they really want to focus on that. So let's assume that this was a year or so ago prior to the COVID lockdown. They decided they want to go on a cruise. They've heard from their friends how great cruises are, how much fun they had, and they like the idea of traveling on a big ship. So they decide that they're going to go to Fiji. Around this time, John Q also decides that if he's going to go on this cruise, he's going to work on his fitness and health so that he looks a little bit better in a swimsuit. So he starts working out very heavily, and he's really trying to improve his health. So he takes up jogging. He used to be a runner when he was young, so it was sort of a natural fit for him. Well, one day, John Q is out on a jog, and suddenly he suffers a heart attack. Well, thankfully for him, they live in a very friendly neighborhood, and his neighbor spots him right away, calls 911, and he goes to the hospital, and he survives. And he actually survives without really any negative effects. Meanwhile, Mary comes to the hospital, and of course, she's very shaken up. And so she says to John, I don't know about this vacation. I feel like maybe we should be prioritizing other things over our vacation right now, including setting up a will. John Q says, you know what, Mary, I agree with you. So why don't you call that attorney who helped us about 30 years ago when we bought our house, and we'll see if there's something that he can do for us. So Mary does exactly that. She calls the attorney, and he says to her, Mary, I'm a real estate attorney. So I really don't prepare wills or anything like that, but what are you looking for? And I'll see if I can help. So Mary tells him, well, we just need something very simple. If John Q dies, he wants everything to go to me. If I die first, I want everything to go to John Q. And then when both of us are gone, We want our assets to go to our children equally. So the attorney says, oh, well, I can do that. And he prepares wills for them, and they go to the office and they sign the wills. So now they feel a lot better because they've got their estate planning documents in place, and they feel like they can relax a little and focus on the other things that they'd like to accomplish on their list. So John Q finally gets to go ahead to start working out again. And one day, while he's working out at the gym, he suffers a stroke. Well, this time, John Q is not as lucky as he was the first time. He's transported to the hospital quickly, but he's had a lot of negative consequences from the stroke. He's got some hearing loss. He's got some double vision. He's a right-handed person, and his right hand no longer works, so he can't sign his name. And he's also got some memory loss and some cognitive issues. So Mary is looking at John Q, and she's thinking, wow, this is not my husband. This is a different person who I'm dealing with. And she realizes now that, he may not be able to handle things anymore. He can't quite process information the way he used to, because he used to handle all of their finances and bill payments, and now he just can't do that. So for all intents and purposes, John Q is considered disabled, and that's going to be a problem. So Mary decides that she's going to go to John Q's bank and go ahead and add herself to his separate bank account. When she gets to the bank, she's told, however, she can't do this without his permission. Now, John Q is very forgetful at this point, and he really doesn't understand what she's doing or why, and he really doesn't have the ability to consent to Mary being added to his account. So, because the account is just in his name, Mary cannot access the money. Now, she also realizes this when she calls the retirement company, that they will not give her any information. So the problem here is that Mary has a will and John Q has a will, but wills are only effective at death. They indicate how assets will be distributed when somebody dies, but John Q and Mary are still alive. Now that's a big problem for them. So the only recourse for Mary is that she's going to have to go to court. So she goes to court for what is called a conservatorship, sometimes also called a guardianship. And it's a proceeding that's designed to have someone appointed to handle the affairs of a person who is no longer capable of managing their own finances or their own affairs. Now, it's not typically a very pleasant process, and something that you necessarily don't want to have to go through. It can be very humiliating for the individual because we must talk to them, we must talk about them, and we have to say, well, they're not capable, and the doctor's going to have to certify in writing or testify to that in person. So the court is going to be in complete control of what happens with this person's life. And it can take a while. Court calendar can be quite congested. It ebbs and flows, but there are times when you can't get a hearing for a long time. And in that case, no one can access any finances during that period. It can be a real problem and can also be very frustrating. Well, conservatorship is also very expensive. There are a lot of fees that are related to the process. You have to pay court fees just for filing the case. You must also pay the attorney who is hired to go to court, and then there are the accounting fees, because every year a conservator has to present an accounting to the court and to the individual whose money that they are managing. As you can imagine, it's a lot of work and it's a lot of hassle, but they have no choice. So they go through this process, and Mary is appointed as John's conservator. Now she's handling all of the finances and finally has access to all of his accounts. However, soon after that, John Q succumbs to the complications from the stroke. So John is now dead. So at this point, Mary remembers, well, we've got a will. John had a will, I've got a will. And the will says when he dies, he wants everything to go to me. So she figured that everything would work simply because she's his wife and there shouldn't be any issue. But it turns out there is an issue. So Mary now has to return to the court for a second time. This time, she's going to go through what is called probate. And she discovers, besides the separate bank account, John Q had also forgotten that he had inherited a vacant lot on Maui from his grandfather. And he had really intended to sell that or transfer it to the kids at some point. But because of that, he never bothered to add Mary's name to the deed. So now this property has to go through probate, which is the process of changing title from the deceased person to the new owner or beneficiary. John Q had believed that everything would just go directly from him to Mary, but unfortunately, it's not that simple. So again, they must go to court, Mary and the kids, and they're going to have to pay off any valid creditors who show up and make claims. Now, they're also going to have to do an inventory of the assets that are in John Q's name and have an appraisal done of all of those assets. And then finally, they get to distribute the assets. So probate is an expensive process. It's not cheap. Number one, you cannot navigate the probate on your own. Some people may try, but court clerks can't give any legal advice and nobody else can give any advice. So they discover that they must hire an attorney who specializes in this area to go to court with them and represent them. Now, there are also court fees, filing fees. There are publication and bond fees. You got to publish a notice to creditors in the newspaper. Now, here in Hawaii, that alone will cost you over $1,000. You may have seen those fine print notices in the Star Advertiser. Well, the executor who is appointed by the court to manage probate is also going to get paid. And of course, the attorney is going to get paid. Now, when it comes to fees, probate attorney fees, there are two major methods of calculating compensation. So in Hawaii, we use what's called the reasonable compensation standard. And this means that the attorney will handle the file and they'll keep track of the number of hours that they've spent working on it. At the end, they'll present an affidavit that says, I spent X number of hours, this is my hourly rate, therefore I should get paid this amount of money. Now the judge, who prior to becoming a judge was also an attorney, is going to look at that affidavit and review it. And he's going to say, yep, that's reasonable. And that's what the attorney will get paid. So whether you or I would agree that it's a reasonable payment to the attorney, it doesn't come into play. The judge is going to make that decision. That's reasonable compensation. Now, in other states like California, they follow what's known as the percentage of the estate standard. And the reason I mention this is because Hawaii may switch over to this standard at any point in the future. Now, here's an example of the percentage of the estate. We also do this in Missouri, where I still have my virtual practice. So let's imagine that there's an estate total value, just like here, $900,000. There's some minor assets in the estate, but the major asset is a house. And the house happens to have a $400,000 mortgage. So the true equity and the net value of the entire estate is about $500,000. So the attorney is going to get paid a percentage of the estate. So you ask yourself, what are they getting paid off? The gross estate or off the net? Well, you would think it's because what they really only have is $500,000. It would be the net estate. No, no, no. The probate attorney is actually going to get paid off of the gross estate, which is typically about 2 to 3% on average. Now think about this in your own case. If you own real estate or multiple properties, you just figure out what 2 to 3% of the gross value, not considering your mortgages, are. That may be a lot of money. So that's what the attorney is going to get paid. So that's a concern. And all of this can be avoided just by having your estate plan set up ahead of time. Now, we also know that probate takes time, on average 1 to 2 years from start to finish, although some probates can take much longer than that, running into decades. Probate is also a very public proceeding. Everything's exposed. There are many courts, like family court, where it's private and people can't just go in and sit there and hear what's going on. But probate court is different. So if you would like, you can go in and you can show up to probate court and listen to all the hearings coming before the judge that day. Now, for a lot of people, that's very uncomfortable. They don't want their friends or neighbors to be aware of what happened with their estate or what's going on with their family. There's also the issue of multiple probates. If you own real estate here in Hawaii, as well as a vacation home in Vegas or that other property in California, you could potentially be facing probate in all 3 of those states because real estate is going to be probated in the state in which it's located. So you want to make sure that you have an estate plan set up ahead of time where you can move all of those assets into a trust and avoid probate in multiple locations. So to review, there's a lot of disadvantages to probate. It's expensive, it's time consuming, it's public, and then there's the issue of multiple probates. So now I'm going to talk about death taxes. A couple of people here have indicated that they're concerned about death taxes, which is alternatively known as the estate tax or the federal estate tax, and also the state estate tax. Now, the government says you have to pay a tax on the privilege of transferring your property to someone else upon your death. Many bureaucrats hold the belief that the collective should own all, and they know better than you do, or you and I do, about who should become and what should become of your property. You know, in their benevolent wisdom, they've legislated how much of your assets you may pass free of tax. The law calls this the exempt amount. Now, this number has changed drastically over the years. In the mid-90s to the early 2000s, the threshold was about $600,000 to $650,000 per person. So what that meant is if you passed away and your estate was over $600,000 in total value, then you would have to pay an estate tax. Your assets would be taxed before anything would be given to your beneficiaries. Now that number, as I mentioned, has changed, and I'll show you where we are today in a minute. But I also wanted to mention another type of tax, which is the inheritance tax. Some states also add this inheritance tax, which is levied on a beneficiary. This is considered a tax on the right to receive property. Now in Hawaii, we don't have a beneficiary or an inheritance tax, so no tax on the beneficiary. We do have the federal estate tax, and we also have the state of Hawaii estate tax. So each state sets their own exempt amount threshold. And the result is that you may have a Hawaii estate tax, even though you may not owe federal estate taxes. So let's look at an example. I mentioned that at one point, the federal exempt amount was about $650,000 per person. Where we are today now, if you scroll all the way down to the bottom, we're looking at 11.58 million. Nope, your eyes don't deceive you. That shows you that if your total assets are under $11,580,000, you will not have to pay any estate tax. Now, for most of us, that's a pretty good deal right now. But if there's one thing that I can guarantee you, having done this for 40 years, is that number will change just like it's changed so many times in the past. You see the chart at 2000, in the year 2010, the estate tax was eliminated entirely for 1 year. So if you were lucky enough, sort of tongue in cheek, if any of us are lucky enough to die, but if you died in the year 2010 before December 31st, regardless of how large your estate was, you would owe zero in federal estate taxes. Now, Congress was debating raising or lowering the estate tax exemption. So they talked about lowering the exemption down to $1 million, and then they got very close to doing so, but then they settled at $5 million. Now, they said it was a permanent change and that it would be adjusted annually with the rate of inflation. But we knew that it was only permanent until Congress changed their mind, which they did at the end of 2017. The Republican tax cut was passed and doubled the estate tax exemption. So in 2018, the exemption was projected to be $5.6 million per person, but it was instead doubled to $11.2 million. Now with inflation, we're now at $11.58 million. But remember, what Congress gives, Congress also takes back. This tax included what's called a sunset provision, which said that it would end in the year 2025. So in 5 years, the exempt amount is supposed to drop back down to about $5 million. Now that's still a very high threshold for most of us, but with real estate values here, maybe not so much. And as I mentioned, this threshold, it does apply to every person. So if you have a spouse, you have double that amount properly structured from 5 million to 11.58 million times 2. Finally, if you're fortunate enough to have assets over the exempt amount, I want to mention that the tax rate is 40% of whatever exceeds that amount. And that's just the federal government's share. In Hawaii, our estate tax rate is 20% of whatever amount is over the exempt amount. So Hawaii has always historically mirrored the federal exemption. The result being that if you were exempt from federal estate taxes, you were also exempt from Hawaii state taxes. Now that's until 2018 when the federal exemption doubled. So Hawaii saw a potentially significant revenue loss. So they kept the Hawaii state exemption at 5.49 million, and that's where it continues to be right now. So what's this mean for you? Well, let's assume that you have an estate worth $6 or $7 million. In that case, you will not have to pay a federal estate tax, but you will have to pay a Hawaii state estate tax of 20% of the amount over the exemption. Okay, so these are the two different tax exemptions and the amounts that you need to be aware of. There's also an interesting estate tax provision we call the unlimited marital deduction. Now, this is available to anyone who has a surviving spouse who is a U.S. citizen. Now, if you die and you leave $30 million to your surviving spouse, you will not be taxed at your spouse's death. So the estate avoids the estate tax and the entire amount of money goes to your surviving spouse. Now, if that sounds a little too good to be true, it kind of is, because at your spouse's death, whatever is in their estate at that time, including the money that you left, will be taxed. So what you've really done is delay the payment of the tax. It's just a tax deferral. Now, I should note that this only applies if your surviving spouse is a U.S. citizen. If your surviving spouse is not a U.S. citizen, you're not able to leave an unlimited amount of money to them. The reason why is because Congress recognized that a non-U.S. citizen surviving spouse may be unlikely to remain in the U.S. after their spouse dies. They're likely to get the inherited funds and possibly go back to their home country. And if they do that, the IRS would lose the ability to tax the assets. So you may be thinking now, well, I'm not too concerned about the estate tax now that I see the exemption amounts. but you should be concerned about a conservatorship and a probate. So if you want to be able to control whom you want to receive your assets, when they will receive the assets, and have your estate handled by the person of your choosing. Getting back to our story, just for the sake of keeping the math simple, we're going to assume that Mary survived the conservatorship and the probate for her husband, and now she's got about $900,000 in assets. An interesting fact, and we like to share with our clients, is that the surviving spouse typically lives about 7 years after the death of their spouse. Now, I don't want you to worry that if your spouse died 6 years ago, you only got a few days, weeks, or months to live. We hope you have much more time than that, but it is an interesting fact that we would like to share with our attendees. So Mary, she's going to beat the odds. She's going to live 10 years after the death of John Q. And in that time, she's going to invest her money very well. She's going to double the size of her estate. So now she has $1.8 million. Two important considerations that people raise when they come to see us. They're worried about remarriage, that their estate could end up in the hands of a second spouse should their spouse remarry. And they're also worried about lawsuits and predators, that their spouse could get sued or preyed upon and lose all that hard-earned money. Now, these are realistic considerations. So speaking of people who enter our lives, this is where Oscar the Opportunist enters the picture. You remember him from earlier? Well, Oscar is a neighbor of John Q and Mary. Now, they really never socialized with him, mainly because John Q didn't really care for Oscar. He felt Oscar was a little too interested in Mary and everything that she was doing, and so they kind of avoided him. So, as often happens, as soon as John Q is out of the picture, Oscar starts coming over to help Mary. And at first, he's just doing the neighborly thing. He's helping around the yard, doing repairs around the house. And then he's coming over for coffee in the morning and then dinner. And the next thing you know, they're in a relationship. Now, Mary's very happy to have a companion in Oscar. But Oscar's had a previous marriage too. And he's got 3 older children. And so they're saying, you know, Dad, we hear Mary's got a lot of money. And if you get married, maybe you'd have a lot of money. So this conversation is sort of going on in the background. But again, Mary's very happy. Well, Susan, who's been helping her mom ever since her father passed away, is starting to notice that Mary is more forgetful than usual, and she's getting a little mixed up. And her bookkeeping is kind of a mess. So Susan takes over everything because she's a CPA and quite good at managing finances. And Susan decides that she needs to take Mary to the doctor to see what's going on with her mentally. While at the doctor, Mary is diagnosed with Alzheimer's. Now, if you've ever known anyone who's had Alzheimer's or suffered from this illness, you know that if you have full-blown Alzheimer's, you are definitely not capable of managing your own affairs. Somebody else is going to have to step in and do things for you. So if you recall, John Q and Mary originally set up their estate plan, and they only prepared simple, I call them I love you wills. So John Q had a will, Mary had a will, and remember that the will only kicks in at death. So now we've got another problem here. There's no document in place that will allow somebody to handle the finances for Mary. So unfortunately, they find themselves going to court for a third time for a conservatorship for Mary. And it's likely that Susan will show up and she's going to say that she's been managing mom's bookkeeping for the last couple of years, that she's good with numbers, she's a CPA, and she should just be given the legal authority to do so from here on out. Now, Jack's probably going to say, hey, I'm the son, I'm the oldest child, I'm the one to be named. I'm responsible, I'm smart. Maybe he's wearing a suit. Maybe he got a job and cleaned up his act. Things could have changed since his party boy days. But the point is, they're each going to make a case for being mom's appointed conservator. And we all know that Oscar is likely to show up as well because he's been in a relationship with Mary for all these years. And he feels he knows her best, what bills she pays, what she would want, and all of that. So he's also being asked to be named as her conservator. Of course, they must go through the same process and show that Mary is no longer competent and that her doctor has declared that she's got Alzheimer's. Again, it's going to be expensive. It's going to take a while, and it could be quite a fight or perhaps just a hassle. But the judge is going to entertain all of this information and then decide. Now, in my opinion, the best decision would be to name Susan as her conservator, but you never know what the judge will rule. So let's assume that Susan is eventually named, and now she's handling things for her mother. And then her mother passes away. So you probably figured out by now that since Mary's only got that simple will, we're headed back to court again. So they have to go through another probate. Now, a reasonably conservative estimate tells us that it's going to cost us about $54,000 for this probate. And even if John Q. and Mary had maintained joint tenancy of those assets, it wouldn't have done anything for them. As I mentioned earlier, that's a Band-Aid solution. It's not a long-term solution because now both owners of the properties are deceased. So all Mary's assets become untitled at her death and have to go through this probate process. Given the size of Mary's estate, there's no federal or Hawaii estate taxes due, so that's a good thing. The only thing they had to pay, which is still substantial, is the conservatorships and the probates, totaling about $74,000. Now, if there was a taxable estate, if Mary was over that threshold of 11.58 million, you should know that the IRS expects to be paid within 9 months of the date of death. So even if the money's not available because it's tied up in a probate, the IRS doesn't care. They want to get paid within 9 months. So this can be a big problem. John Q. and Mary, when they first talked about setting up their estate plan, they were pretty clear that they just wanted everything to go to the two kids equally. So now they would split about $1.8 million less the fees. But you see, parents have a lot of concerns when they think about their children inheriting assets. The number one concern that we hear from most of our clients is they're concerned that their kids will get divorced and all that hard-earned money that they worked for years to accumulate and the kids later inherited would be split in the event of a divorce. Parents also worry about opportunistic people taking advantage of their kids, and they worry about lawsuits. Of course, parents can't prevent all of these things from occurring, but they can minimize the impact of these events through careful planning. Now, I want to talk a little bit about Susan's situation. Susan, I didn't mention earlier, but she's married and she has a husband named Jason. Jason's very similar to his brother-in-law, Jack, in that he really doesn't care to work or hold a regular job. You know, he spends his days at home watching sports on TV, and that's his life. Meanwhile, Susan is working a full-time job, operating her business, and she's been taking care of her mother. She gets no help whatsoever from Jason, and she's getting kind of tired of this arrangement. So she decides she's going to file for divorce. Now, if Susan had inherited the $900,000, her share from her mother, and placed it into a joint account with her husband, Jason, she would have effectively commingled that money. It would have become what's called a marital asset. And in the event of divorce, Jason is going to ask for and likely receive half of that money. So that probably wouldn't have been the best way to handle things. Now, as for Jack, he's got other issues. He probably will take his money, go out and buy a fancy sports car, and take up drag racing up and down the street. Perhaps one day while he's doing that, he hits a pedestrian. This person goes to the hospital and they die. Now, Jack has not only criminal liability, but he also has civil liability. The family of the pedestrian is going to take him to court and sue him for all the money that he had inherited. So again, John Q and Mary have worked hard all these years for their kids to lose all this money to divorce and to lawsuits. And we think there's got to be a better alternative. And the better alternative is the Revocable Living Trust. So I'm going to talk about the Revocable Living Trust now and how that works so that you can see the difference between how having a trust works versus having simple I love you wills that John Q and Mary originally set up that really didn't do all that much for them. Now, we'd like for you to think of a trust. And when I say trust or living trust or revocable living trust, I'm using all of those terms interchangeably to refer to a revocable living trust, which is a trust that you establish during your lifetime that you own and have control over. Now, we like to think of this trust as a treasure chest or a box that owns title to assets. So rather than you as an individual owning your house, or you and your spouse owning the house or other assets, your trust becomes the owner. Now we're going to wave our magic wand and bring John Q and Mary back to life. So rather than creating simple wills, we're going to create a living trust. And we want to see how that works out for them. The first and most important step in any trust is to fund the trust. We must transfer assets. So that includes our house, our real estate, our bank accounts, investments, CDs, mutual funds, stocks and bonds, all those things. Now the trust will only control what's in it. So if you do not place assets into your trust, you will face the possibility of probate. So it's a really good idea to fund that trust. Now, there are three titles or positions that come into play when forming a trust. There are grantors, trustees, and beneficiaries. The grantors are the owners and the creators of the trust. The trustees get to manage. They're buying and selling, refinancing, paying bills, and doing the day-to-day management of the assets within the trust. And the beneficiaries, of course, get to use the assets. They spend the money and use the assets. Now, to summarize, grantors create the trust and own the assets. Trustees manage the assets, and beneficiaries use the assets. John Q and Mary are wearing all three hats here. They are the grantors, also sometimes called trustors or settlors. They are the trustees, and they are the beneficiaries. So they're free to use whatever assets they have, even to the extent of exhausting everything while they're alive. And nobody else can say anything about that. So it's really business as usual. When you set up a trust, it's not that different from before in that you still get full use and control of your assets. Now, if you had a trust and you wanted to make changes, you'll see that you can amend that trust, or you can even revoke it, which means to get rid of it altogether if you decide to do so. That's totally within your authority and your control. And you can still refinance. There's no new income tax form. You do your regular income tax filing, and there's no change in your property taxes. So you go ahead and you keep that homeowner's exemption that you currently have on your primary residence, even if your home is moved into your trust. So you may be thinking, well, why would I create a living trust? Well, we like to think of it as a decision making backup generator. It's going to kick in the event of your death or your disability. And one of the most important features is that it avoids court involvement. Now, this is how John Q. and Mary's Living Trust is established and set up. John Q. and Mary create one trust. And the reason that they do that is they don't each need their own. They own everything together. They just want one pot that they're both controlling and using. Now you can see that while John Q. and Mary are both alive, they're both the beneficiaries. And when one spouse dies, the survivor is the beneficiary. And then when they're both deceased, their children are the beneficiaries. Now, next to John Q. and Mary's picture, there are three special assets: checking account, life insurance policy, and an IRA. And I want you to know about what I want you to know about these items is that all of those assets may be what's called beneficiary designated, and they're often transferred outside of the trust. When, excuse me, when you apply for a life insurance policy or open an IRA, you fill out a beneficiary form. The companies do not care if you have a trust. What they care about is that you've named a beneficiary, because that's who they're going to transfer the assets to upon your death. So retirement accounts, annuities, pensions may stay out of the trust with a beneficiary designation. And the same's true with life insurance. Now, you can name your trust the beneficiary of your life insurance, and I believe that there are substantial benefits to doing so, but that's really a longer discussion, and I'm not going to get into that right now. For regular checking accounts, most clients retitle the account into their trust. However, some clients do decide to leave one or two accounts out and keep those accounts in their individual name or in joint ownership with their spouse. Usually this is a checking account where the money comes in and goes right back out to pay bills. And the reason that they decide to do this is because when it comes to moving existing accounts into your trust, there are different rules for different institutions. Some banks and credit unions will tell you, no problem, we'll just change this to a trust account. You keep the same account number, everything's the same. So other banks may tell you that you need to open a trust account. In order to open a trust account, you must close your existing account and move everything into the new trust account. And there are some credit unions that will tell you that the trust is an ineligible member and simply will not allow trust accounts. So when you hear this and you already got automatic bill payments set up, and you're going to say, no, thank you. I'm just going to leave it as is. And for the most part, it's not a problem to do this. So getting back to our story, you recall that the first time around, John Q had a stroke and things did not work out too well for him. They had to establish a conservatorship and have the judge decide who would handle things for him. This time, they don't have to go through that process because the living trust, because of the living trust, they already established has instructions about how and who will handle things in the event of one spouse's disability. In this case, Mary is going to continue in charge. She doesn't have to go through a conservatorship to get authority to handle John Q's affairs. She also already had him sign a durable power of attorney so that she can handle all his finances, including things inside and outside of the trust. As a result, they save a lot of money because they don't have to pay anything for the conservatorship. And when John Q passes away eventually as a result of his injuries, They will also avoid a death probate. So if you recall, the main purpose of probate is to change ownership of the assets from the deceased person to the new owner. When they're both alive and well, they funded their trust. In other words, they retitled everything to their trust. There's no need for probate because even though John Q is gone, the trust is still in place. Mary still has control over all of the assets that they put into the trust. And as a result of having funded the trust, they will avoid probate and all of the fees, costs, delays, publicity, and hassle associated with that probate. Now, there's another type of trust structure that married couples sometimes establish, and we call that the AB trust. You may have also heard it referred to as a non-marital trust. Now, it's a little different because the trust splits into two subtrusts at the death of the first spouse. And the A trust represents the share of the living spouse, and the B trust represents the share of the deceased spouse. Now, the primary reason for this structure is that it used to be used for estate tax benefits. When the exemption amount was only $600,000, married couples wanted to maximize the amount that they could pass on tax-free to their beneficiaries. By using the AB subtrust structure, they were able to pass a full $1.2 million tax-free and defer the payment of estate taxes until the death of the survivor. Now that the exemption amount is $11.58 million per person, we typically do not need to break these two subtrusts into these two subtrusts, and it's more of a hassle than it's worth for many people. And that's because although the surviving spouse receives all of the income that flows from the assets in the family trust, and they can use the principal for their health, education, maintenance, and support, they cannot fully control the family trust. Now that's locked up. It's in an irrevocable trust that must file a tax return every year, also get its own tax ID number. The A trust, the survivor's trust, is the only portion that is under the full control and authority of the surviving spouse. Now, as I said earlier, because of the substantially increased exemption amount, this structure is only used for tax purposes in larger estates. But there's another reason couples may wish to consider the use of an AB trust. And that's when it comes to Oscar. So Oscar or any new spouse cannot access the B trust, that family trust that we've set up. Even if Oscar had convinced Mary to pull cash, pull everything out of the trust that she controlled and combined it with him, she's restricted. She can only control the assets in the A trust, which is the survivor's trust, and she can do whatever she wants to with that. But as to the B trust, she's much more limited. She can only take income or principal for her needs. If she doesn't have any need for that money, it must remain in trust. And eventually, it will go to her two kids at her death. So you think about it, and that's a potentially huge benefit of the AB trust structure. But only you can decide if that's right for your situation. And we know that in our example, Mary developed Alzheimer's, and things did not go well for her the first time. She had to go to court, or the family had to go to court for Mary's conservatorship. This time, they're going to avoid that conservatorship because the trust already had instructions as to what would happen when somebody became disabled. They had the foresight to appoint Susan to handle things, and she continued to do so until Mary passed away. At that point, the trust really kicked into high gear. Now, will her estate go into probate? I think you understand at this point that it will not. There's no need for probate because they set up their trust and they properly funded it. They transferred all of the important assets to their trust. So again, they get to avoid probate and all of the other fees, costs, and other issues associated with that probate. Now, as a result of successful trust planning, Mary invested well and doubled the size of her estate. So at her death, half of it went to Jack and half went to Susan. Now, Susan is the successor trustee. So she's going to manage everything for herself and for her brother. Now, if you're a single person, your trust looks slightly different. You're missing that middle area. So at your death, everything just goes down to your beneficiaries, and they get to avoid estate tax on anything under 5.8 million. Now, if you recall the discussion about Jason, Susan's husband, what John Q. and Mary could have considered is setting up a divorce protection trust for Susan. Now, this is a common feature that many of our clients here at IEDS have utilized. It allows for the creation of a subtrust under the parent's original trust. Susan would have been able to keep her share separate from her husband. So instead of taking all that money and putting it in a joint bank account, she would open an account under her divorce protection trust name, and she would keep all that money separate. Then, in the event of divorce, she can show that, number one, she inherited the money, and secondly, she kept it as a separate asset. The result is that it's her money, and she's going to walk away with it. Now, there's also a possibility of creating a creditor protection trust. That would have been helpful for Jack because he's no good with money and he makes bad decisions. This requires a third-party trustee, so Susan or some other person would act as a gatekeeper for Jack. He's not going to own or control this money. It's set aside for his benefit, but he must have a demonstrated need for the money for distributions to be made. This protects Jack because if he's sued or he has creditors coming after him, they cannot reach in and grab this money. They cannot force a third-party trustee to distribute the money to him. So as long as the money stays in the creditor protection trust, nobody can reach it. Now, Jack could have also had an incentive trust. Maybe John Q. and Mary saw that when Jack was reaching the end of, when they were reaching the end of their lives, that Jack was really trying to better himself. Perhaps he'd gone back to school. Maybe he'd gotten a part-time job. So they really wanted to encourage that behavior. And if so, they could have set up an incentive trust in which they set certain guidelines. Now, if Jack met those guidelines, then he would be able to get distributions from his trust. So perhaps Jack was able to get a full-time job, go back to school. He's taken random drug tests and tests negative before he gets a distribution. They could have set it up however they'd like to, and Susan would probably be the gatekeeper to make distributions if Jack met those conditions. If they had a special family needs, if they had a special needs family member, somebody who was disabled or not competent, they could have set up a special subtrust for this individual as well. The money would have been held for the benefit of this person, managed by a trustee. And it's done in a way where the person does not get disqualified from their benefits. We don't want them to get kicked off benefits, but the money's there to enhance their lives. You know, if they need money for clothing or toiletries or entertainment, or for other purposes that are not covered by their government benefits, you know, the money would be available to them and they would not get disqualified from their benefits. Now, do you have a fur baby that has worked its way into your heart, home, and wallet? From a legal perspective, pets are typically considered tangible personal property. Parents know to name guardians for their children, but what happens to pets when their human parents pass away? Well, there are two steps that you can take to ensure that your pets are covered by an appropriate estate plan. First, you need to choose a caretaker. Second, you need to put it in writing. So a pet trust identifies your pet by name, designates a caretaker, appoints a trustee to manage any set aside money, and dictates the type of care that your pet will receive after you're gone. The trustee of the trust will oversee the money and will have the legal responsibility to ensure that the caretaker uses the money as ordered by the trust, including food, veterinary care, routine medication, supplements, and any other recurring costs over your pet's life. You know, the pet will live with the caretaker who will see to their daily needs. And you'll rest easy knowing that your four-legged family member will be in good hands. So getting back to our story, as a result of the second go-around of setting up a revocable living trust, John Q. and Mary have saved quite a lot of money, about $74,000 in total. Now we know that all estate plans are not created equal. Some of them really do stink. And we caution you about setting up something on your own or downloading documents from the internet, because you don't know what you're getting and you don't know what you don't know. Done incorrectly, your estate may end up going through probate anyway, and that probate may cost you many more times than what you would have paid just to set up a proper estate plan using a professional drafting service or an estate planning attorney. Now, you've seen that there are a lot of advantages to a living trust. You can see that you're able to control whom you want to receive your assets, when they will receive the assets, and who is going to handle the estate for you. And you get to avoid all of the fees and costs associated with conservatorship, probate, and in larger estates, death taxes. Now, there are a lot of pieces to an estate planning puzzle. So what we've talked about so far today is about the last will and testament and a revocable living trust. But there are many more documents that comprise a comprehensive plan. And you need all of these documents to have everything in order. Now, the pour-over will is a last will and testament, but it is a special type of will that is connected to your trust. So what it says is, if I die and I have any assets that are still in my name, like a small bank account, then it's going to get poured over into my trust at my death. That asset or assets will be then distributed according to the terms of the trust. Now, you should also have a power of attorney, which I'll talk about in a second. Also, a property agreement if you live in a community property state. Your healthcare documents should be in order, as well as all of your financial planning documents. Now, the durable power of attorney is a very important document. It allows you to name a trustworthy person or persons to manage your legal and financial matters while you're still alive. Now, that is the key to this document. It's good only when you're alive, and it automatically expires at your death. The reason you would want to have this document in place is if one day you're disabled or incapacitated, you need this document so that somebody can pay your bills, access your bank accounts, file your taxes, and take care of everything. If you do not have this document in place and you become disabled, your family must go to court, as we've seen, for a guardianship or conservatorship. Now, you should also have your advanced healthcare directive. In the past, here in Hawaii, we've used two different types of documents, the living will and the healthcare power of attorney. Well, in 1999, Hawaii combined these two documents into one, which is now known as the Advanced Healthcare Directive. So in this document, first you're naming agents who are going to carry out your wishes, and those are usually your spouse, your children, or other trustworthy family members or friends. Second, after you name your agents, you're going to make your what are called end of life decisions. You're going to decide when you want your agents to be able to handle things for you. You're going to decide if you want to be kept on life support, on a ventilator, whether you want artificial feeding or artificial nutrition and hydration, and whether you would want pain medication administered to you, knowing that it may hasten or speed up your death. Now, these are very important personal decisions that you need to make ahead of time. You may also wish to talk to your doctor about it. Just make sure that you really understand the decisions that you're making. This helps your family so much to have direction when put in the position to carry out those wishes. Now, HIPAA is a privacy law that says that doctors, nurses, hospitals, and insurance companies cannot give out your confidential information without your permission. So if you want your family members to have access to this information, be able to talk to the doctor about your condition, if you're hospitalized, then it's important for you to have this document with those people's name on it. So your complete estate plan will include your living trust, your will, all of the other documents that I've talked about, and some others that we really haven't touched on yet. So we're nearing the end here, but I do want to address the issue of fees. We believe that fees and costs typically go hand in hand with the type of service that you receive. Now, most of the time, you really do get what you pay for, but there are times when you can get tremendous value by educating yourself in what is important and finding a company that you can trust to deliver high quality and fair cost. Now, perhaps you've downloaded some Susie Orman documents, or you've looked at Quicken, Willmaker, Rocket Lawyer, or an online service like Trust and Will, or even LegalZoom. Now, those have their place for simple documents in certain areas of the law. I personally refer to these type of products and services as McWill types. And most professionals in the estate planning field would probably warn you against using them for a variety of reasons. Chief among them, their lack of flexibility to achieve your specific goals. They just don't have the power to do that. So when it comes to estate planning, you really need a professional drafting system to assure that you get a professional result. Now, you could also consider working with a local law firm or a sole practitioner. There are a lot of good estate planning attorneys in Hawaii. So you need to consider carefully what you get and what it's going to cost you. As I mentioned at the beginning of this webinar, our tagline says, used by lawyers. All online document preparers will tell you that their documents are drafted by lawyers. Well, does anyone seriously believe that an estate planning attorney would use LegalZoom to prepare their own documents? At IEDS, our document drafting system is the same used by thousands of practicing attorneys in their own offices. As I mentioned, I use it in mine. It is state specific and continually updated for any changes to applicable laws. Now, I'll tell you, I have a real passion for making sure that families have access to the best legal documents possible, so they truly achieve the outcome they desire. To borrow a line from an insurance company commercial, we know a thing or two because we've seen a thing or two. Well, my experience as both a financial planner and an estate planning attorney helped me understand what keeps people from implementing their plans. First, trust is one of the most important factors. So I would like to offer you some time to ask questions and get answers as to whether IEDS is right for you. I never charge for phone calls or technical assistance as you create your customized estate planning documents. Now, you may well be thinking at this point, well, What if things change? I set it up 10 years from now, and now I want to overhaul it. Well, things will change. Laws will change. Your wishes will change. Your family structure will change. Maybe the strategies available to us will change. And that's why we want to keep in touch with you. We send you newsletters every other month, and we encourage you to do regular trust reviews. Now, when you use IEDS to draft your estate planning documents, you can rest easy knowing that any changes you want won't cost you dearly from a financial perspective. For 1 year after the creation of your plan, any changes are completely free. Now, after that year, we have a very low-cost maintenance plan, and I'll talk to you about that shortly, which will enable you to continue to make changes to your documents, any of your documents, completely for free. Now, we would like to build a continuing long-term relationship with you and keep you informed of legal changes and new planning opportunities that you may wish to consider through our regular emails, blog posts, and newsletters. So what's the cost of failing to plan? Well, for John Q. and Mary, they paid dearly because they did not have everything in order in our first example. Well, we all know that there are certain things that you should avoid trying to get a bargain on. You don't want to get a bargain on a parachute to jump out of a plane. You wouldn't shop around for the cheapest brain surgeon. And if your kitchen catches on fire and none of those fire extinguishers work that you bought at the dollar store, you got a real problem. Now, we believe that your estate planning documents are very similar to these products. And as I said before, most of the time you get what you pay for. Additionally, you don't know if it's going to do a good job until it absolutely must. So we come to this slide. Now, if you're somewhat shocked by this slide, I completely understand. But I need to tell you that this is not the cost of your estate plan when you choose to have your estate planning documents done at Interactive Estate Document System. I recently attended a webinar put on by a local law firm here in Hawaii that does estate planning, and I wanted to share their fees for preparation of the documents that we've been discussing here today, so that you can see here, you can see here that the single person fees are about $3,800 with a webinar attendance credit of $200. So the discounted fee is $3,600. But be sure and notice that if you want them to prepare a deed to move your home into the trust, there's an additional fee of $400, bringing the total fee back to $4,000 plus recording fees. And for any additional real estate properties that you may have, it's an additional $400 plus recording fees, which are either $86 or $41, depending on whether the property is recorded in the land court system or the regular system. And if you're married, their standard fees range between $5,200 and $5,700 after their seminar credit, and assuming that you have one real estate property to transfer to trust. And so what does the law firm include for those fees? Well, it includes your living trust, your will, your durable power of attorney, your advanced healthcare directive, your HIPAA, medical privacy form, and communication with the law firm. And they also provide you a nice little fake leather binder to keep your documents in, an explanation of your documents, location list, title transfer instructions, and a short form trust agreement. I attended another local law firm's webinar just the other day, and here's what they charge. Now, I would note here that the family plan over on the left-hand side did not include a revocable living trust, but only a simple will. Okay. Now, I share this information with you not in any way to challenge or disparage their fees, and certainly not to disparage their work. But having done this for quite a while, I know that one of the major reasons that families don't implement their estate plans is cost. On the next couple of slides, I'm going to share with you what you get when you use IEDS to create your estate planning documents. Now, you'll create all the documents that were referenced by the estate planning law firm in their comprehensive plan, plus much more. Number one, you get an easy to read, understand summary of the estate planning provisions that are included in your Revocable Living Trust, and actually the other documents as well. Instructions for the successor trustees and other fiduciaries. Premium personalized probate avoidance revocable living trust. This is the main document. You're going to get a short certification of trust, which is the short form trust that you give to the banks or other entities when you're registering or transferring property into the trust. You're also going to get an assignment of personal property into the trust. You're going to get instructions for the distribution of personal property, which is allowed by state law. And this is an individual list of, if you want to give something to Johnny or Susie individually, maybe a watch or something like that, you can include that in a separate list. You're going to get your last will and testament, which is going to include those pour over provisions that we talked about. You're going to get your durable power of attorney for financial matters. You're going to get your advanced healthcare directive, which we mentioned includes the living will. You're going to get the HIPAA authorization and waiver. And the list continues. You're going to get a digital asset inventory so that you can put together a list of all of the things that you do digitally, your passwords, logins, all of that sort of stuff that is going to be critical for people to know after you're gone. You're going to get a financial assets worksheet. You're going to get a document finder. Where have you put, where do you keep your important documents? You're going to get a key advisor worksheet. You're going to get a close friends and relative worksheet. You're going to get final disposition instructions. That's for your burial or your funeral instructions. You're going to get a specific instructions for transferring assets into your trust. This is detailed by the type of asset that you're going to be transferring into the trust. And you're going to get the actual transfer documents. So the system is going to prepare those as well for you. You're going to get a 1-year complimentary subscription to DocuBank online document vault service with access 24/7, 365 worldwide. And so you're going to be able to get access to those healthcare directives on a moment's notice if you need them. As I mentioned before, you get unlimited revisions for 1 year, and the maintenance plan, as I mentioned, to be able to continue to access the system is only $9 a month. You get all of this when you prepare your documents through IEDS. Now, the truth about estate planning is that you're going to do the heavy lifting. It does not matter if you go to an attorney that charges you $5,000 or more, or you use the services of IEDS online to create the same documents for thousands less. It's still going to be your responsibility to do the heart work. Now, the heart work, as I mentioned, is the wrestling with questions like, who do I want as guardian of my children? Who should control the money that I leave behind? Does my spouse need protection from potential predators and creditors? Do I need to treat my children equally? Is equality the same as fairness? No one can answer these questions and many others for you. This is what makes your estate plan unique. Now, I need to let you understand here that if you use an estate planning attorney to draft your documents, the process will likely follow a predictable pattern. He or she will ask you questions and may share some valuable insights from his or her experience. Now, it's likely that they're going to provide you with a checklist or an organizer to assist you in exploring your goals and objectives in the estate planning process. Now, once you've completed that checklist and answered the questions, the attorney has the information entered into his or her document assembly system, which produces the finished estate planning documents. Now, the process is very similar when you're producing your own estate planning documents using IEDS Online. Now, instead of driving to the attorney's fancy office, which is part of their fixed overhead, which needs to be covered every month, you sit down at your computer and in the comfort and privacy of your home or office, and you can visit, you visit www.ieds, that's Interactive Estate Document Systems, .online. So you go to that website and you explore the many resources that are available to answer questions that you have about the process. Perhaps you download an organizer to help you gather and centralize the information that you need to speed your eventual online document assembly interview. Now, we at Interactive Estate Document Systems believe that since you're doing the time-consuming job of gathering, organizing, inputting your information and wrestling with answering those hard questions, that you should reap the financial benefits. So our regular price for a single individual document package is $797. Now that's the comprehensive package, includes all of the documents we talked about, and $997 for a married couple document package. Now this is an unbelievable value. In fact, I'm often asked, if attorneys are charging thousands of dollars for exactly the same documents you're offering so much less, how and why are you doing it? So I try to explain it in part by a famous Churchill quote. And what he said was, we make a living by what we get, but we make a life by what we give. And I hope that at this point, I'm more on the making a life side of the equation. I would like to reward you for taking your valuable time here today and protect yourself and those you care about. So I would like to offer you the same webinar attendance credit of $200. Now, this credit is only going to be good for the next 24 hours. And the reason for this is that I know from experience that if you don't act on this while it's on your mind now and pressing, our old friend procrastination is right around the corner. Now, you've overcome that initial hurdle to be here today. So please help us help you by taking the next step now. Now, you may be thinking, well, that all sounds great in theory, but I really don't know the difference between a testator and a tater tot. Not to worry. With a little topic-specific education, some definitional help, and the intuitive guided interview in our system, we are certain that you will be equipped to create your own documents. You decide the who, what, where, and when, and the software will handle the how and that pesky legalese necessary to make the how happen. Our website provides lots of helpful, frequently asked questions, topical articles, and instructional videos to assist you in your estate planning. Additionally, we are here via email and telephone to answer any technical questions you may have on the operation of the system and the creation of your documents. As I mentioned before, there's never any charge to speak with you. We want to have your documents accurately reflect your goals, your objectives, and we'll do whatever is necessary to make sure that that happens. The document assembly software that we utilize at IEDS Online, as I mentioned before, is the same one that I use in my private estate planning law practice, where we deal with all types of family structures and business situations. As I mentioned earlier, I am only licensed in the state of Missouri to practice law and therefore cannot provide legal advice here in Hawaii. However, Should you want a legal review of your documents, we can put you in touch with attorneys that utilize the same document assembly software. I want you to understand that these are independent attorneys. We do not operate a lawyer referral service, and we receive nothing from them. They will charge you for the time that they spend, but they will, or they should have, a familiarity with the language utilized in your IEDS.online documents to speed their review and therefore save you both time and money. You know, we always think that we have time. We think we've got all kinds of time. And I think that the current situation in the world is showing us that time is precious and we don't always have as much time as we expect. So it's good that you're here and getting this information. Now, my experience tells me that if you know that this is something you need to do, you really need to act now. Gathering information is great, but taking action is what makes a difference in your situation. Again, I congratulate you for making it to the end of our webinar. It tells me that you care about your family. It indicates a desire to deal with the problems and expense your family may suffer if you die without an estate plan in place. One of the most caring things that you can do is keep people from having to guess what you wanted. I like to say that planning for the future is a love letter that you for those that you leave behind. I would also like to encourage you to share the information you received from this webinar with your family, friends, coworkers, or anyone else. We hear from clients all the time that their parents, brothers, church friends, or neighbors need this done. So please feel free to share. If you need an additional estate organizer or had any problem getting the workbook that was emailed to you prior to the start of the webinar, please just contact us and we'll make sure that you get whatever you need. You can email us anytime at support@ieds.online. To get started, please visit our website and note that the website address is ieds.online. Okay, it's not .com. Choose either the couple plan or the single plan, whichever is appropriate for your situation, and use the coupon code ACTION to receive your $200 webinar assistance discount. Now I'm going to stick around here for a little while and answer some of the questions posed during the webinar. So if you have questions that were not answered, please submit them now in the chat area. You can also submit them to us by email at that email address I gave you, support@ieds.online. Thank you again for attending our webinar. We hope it met your expectations and you received the information that will assist you in creating your perfect estate plan.